I trust that it is the united view of this House that fraud, wherever it occurs, should be pursued with rigour. But that does not mean that a bill which proclaims itself as having that purpose is one that we should simply nod through. The fine print of that bill deserves equally rigorous examination. And when I come to this bill, there are a number of areas that I find concerning. I find the equivalence in terms of investigative powers and the initiation of them between investigating fraud and investigating overpayment troubling, because there is a huge difference between a person who enriches themselves by fraudulent activity and someone who is innocent but is the recipient of an overpayment, not because of a mistake they've made, but because of a mistake that the department has made. That is a huge distinction, morally and every other way. And yet within this bill, it seems to me, there is an equivalence when it comes to the powers of investigation in that regard. And that I find discomforting and unfair. I also find it surprising in some of the detail that we find in this bill. As our law presently stands, someone can only, in the eyes of the law, be regarded and held to be a fraudster if they've been convicted beyond all reasonable doubt of fraud. That is the hallowed, long-standing criminal standard which has to be reached before someone is convicted as a fraudster. But no longer is that the standard when we come to this bill. Indeed, no longer is it for the courts to decide if someone is a fraudster. Now, under clause 50 of this bill, the minister can decide if someone's a fraudster and can decide it not on the criminal standard, but on the balance of probabilities. Look what clause 50 says. The minister may impose a penalty on a person if satisfied on the balance of probabilities that the person has carried out or conspired to carry out fraud. So the minister, on the balance of probabilities, not our courts, the minister decides that someone is a fraudster. Now, how could that be right? How could that be fair? And it gets worse, because when you read clause 50 with clause 52, you discover that the penalty is measured in terms not of what the fraud was in every case, but what the fraud might have been. So you can be penalised on the balance of probabilities, not by a court, but by a minister, not for having obtained anything fraudulently, but what you might have obtained if the fraud had been perfected. I do say to this House, that is taking us far too far. And I do think that that is something that needs to be re-examined. And then I come to clause 91. This astounding provision, this disconnected provision, that you can be disqualified from driving if you have failed to pay back £1,000 of money, whether you got it by fraud or, as I read this, whether you were overpaid it. You can lose your driving licence. And you can lose your driving licence not because you've been convicted of fraud, because when you read 91.2, it says that the schedule that's now being amended will make provision for a liable person to be disqualified. What's a liable person? Well, we have to go to clause 11, and when we go to clause 11, we discovered a liable person is somebody that the minister serves a recovery notice on. So if the minister serves a recovery notice on you, that makes you a liable person under 91, and under 91, if you still haven't paid back £1,000, you can lose your driving licence. Really, I do think that in that measure, we have hugely run away with ourselves in terms of what is proportionate and in terms of what is appropriate. And I do say to the government, there is much here that they need to re-examine in terms of the overreach of this bill. Yes, let's go after fraudsters. Yes, let's recover the money that they should never have had. But let's do it in a way that respects the traditions of our legal system and of the decency in our society, instead of the overreach of some, not all, of some aspects of this bill. Now, this bill does not apply to the area I come from, Northern Ireland. But inevitably, because parity controls the welfare payments that are made in Northern Ireland, there will be parallel, eventually, some reflective legislation of this nature. And that would be needed. Because I do want to say a word, and I want the Minister to take this on board, about the Northern Ireland Executive. The welfare payments in Northern Ireland are demand-led. They're administered by the Northern Ireland Executive, by the Department of Communities. But they are demand-led. And therefore, in that sense, they are not coming out of the Northern Ireland Block Grant. And therefore, it seems to me, there is a tendency within the Northern Ireland Executive to be less rigorous than they ought to be on fraud, because they're not recovering money which would be money misused from the Northern Ireland Block Grant.